Third, Daniels, the presiding judge of the 278th District Court. I will take to be doing a presentation on the judgments. Who will let us know who held. I'm going to one quick moment. Yeah.
Morning, everybody. Thanks for joining me today, or thanks for listening. Also, thanks for being here all week. You guys are doing an excellent service. And if you guys don't remember me, I introduced myself earlier during the week, but it's been a long week. You've had a lot of information. I'm Michael Chambers, as you heard, 1L at South Texas College of Law. You may have seen me back there getting notes from the judge, running errands, doing law clerk things. So today what we're going to be discussing is default judgments. I have my screen sharing. What we're going to do is first start off really general, right? I'm just going to give you the general idea, the gist of it. And then as the presentation progresses, we're going to start looking at actual rules of civil procedure, seeing how they work together, how they play, and how the rule actually functions. Hopefully by the end of it, you guys will have a really good understanding of how a default judgment works, the conditions that are necessary in order for a default judgment to have basis and be warranted. Okay, so yeah, this is our title slide. Rebecca Ross will help me on some of these slides, kind of help me get the gist of it. She's not here today. It was her last day yesterday. She was also here a little bit. I don't know if you guys got to meet her. She was excellent and very helpful. So thank you, Rebecca Ross. Uh, yeah, just to meet the team. And then starting off, right, what is a default judgment? What it's going to be, it's a judgment rendered by the trial court at the plaintiff's request because of a defendant's failure to actually respond in an appropriate manner. We'll see what an appropriate manner and what a timely manner is as the presentation goes on. Important to note just at the beginning is that default judgment really is not going to be available to be rendered against somebody who is a claimant. That's going to generally be a plaintiff, but a default judgment can be rendered against somebody who is a defendant as a result of a false claim. So a third-party defendant can also have a default judgment rendered against them, whereas they would normally be a plaintiff, right? Are we tracking so far? Are there any questions? Excellent. Feel free if you guys have any questions to drop them in as we go along. Yeah, absolutely. So the claimant is going to be the person who's bringing the cause of action, and the defendant's going to be the person who's defending the cause of action. Did that help your understanding of it? Awesome. Another thing before we really get into the rules is understanding when this happens. This is a pretrial matter, so it's going to have to be brought against by the plaintiff before trial actually begins. Uh, because it's at the court's discretion whether or not to actually grant this, it's generally prudent practice to bring it as early as possible. Really, as soon as that due date's not going to be met is when you want to start working on and drafting your motion for a default judgment. Right. So now we're getting into the actual rules. This is the fun part. Yes. Oh, I apologize. See if we can get that to go away. There it is. So it's largely governed by Texas Rules of Civil Procedure 503.1. The point one is very important because there's another relevant rule that we're going to have in our discussion as well, Rule 503.3. So 503.1, the rule that dictates the appropriate conditions for the default judgment, has 5 parts. The first part being Part A, that one really just enumerates the conditions in which the default judgment should arise from, and then it goes on in parts, subparts 1 and 2 to that A, the manner in which the default judgment is rendered. The distinction is really going to hinge on whether or not the claim is based on a written document or not, and we'll discuss that more in depth later. Part B, that dictates the situation that might arise whenever has been filed but hasn't been signed yet. This situation might arise if somebody has already failed to respond by the due date, but they actually do appear or respond before the actual default judgment is signed, right? So if they have 14 days after service, on the 15th day, maybe somebody's getting really after it and they're already starting to file their default judgment. If on that 15th day it hasn't been signed yet and the defendant appears, default judgment can't be ordered. And we'll just discuss a little bit more about what that means actually going on. Section C describes the post-answer default. This is a situation that might arise when somebody might answer an original petition, but as time goes on, they fail to appear for trial. D is a really important section as well. Since the default judgment hinges a lot on whether or not the answer was timely, it's really important to evaluate if notice was sufficient. Notice is being aware of the claim being brought against you, getting served properly with the proper information, proper documents to the proper person, right? Because the person needs to know whether or not they're due to appear. And then E, this section right here, this just kind of dictates what a judgment should look like generally. This is not really unique to default judgments. That's governed by Rule 505, which is the rule that kind of dictates what everything that needs to be in a judgment, no matter what kind of judgment it is. So those 3 rules there at the bottom, because 503, our default judgment rule, has a lot of things at work, it's kind of important to get a discussion going of Rule 502, which is the answer, right? Since the default judgment hinges on whether or not the answer was timely, it's really important that we kind of get a good understanding of what a timely and sufficient answer is. The relevant parts of that rule, the requirements, and the due date. We have a very deep explanations of those on the upcoming slide. 503.3, this is going to be for that B situation in 503.1. That rule really just dictates how trial settings should go, the procedure for doing that. And then Rule 505, as discussed earlier, those are just the rules for how judgments need to look in the state of Texas generally. So our answer. Rule 502.5 begins to say what needs to be in the answer. What's going to need to be in there, the name of the defendants, address, telephone numbers, and just how to reach the actual defendant. Also important to note is that a really general answer that just denies all allegations without a defense is completely sufficient to be an answer, even though it may appear that it's lacking in information. In the right there on that yellow screen, you'll see some of those situations I was talking about with the actual general default judgment rule. 503.1B, that describes whenever they appear before the actual judgment signed. In that second one, right, this is where the defendant initially answers, but then as the proceedings go on, they begin to not answer, right? They do not appear for whatever reason may be. At this point, the court can proceed to hear evidence on liability and damages and can render judgment accordingly. This isn't a default judgment because they still have to, they're still going to be able to hear the evidence and for liability and damages. And at this point, it's entirely possible that the defendant, even though they didn't show up, might have a favorable outcome. Whereas in the other situations, all the claims that are brought against them are going to be sustained. Now moving along, this is the dare I say, the most important part of Rule 502.5. These 2 parts give us the due dates, and the main distinction is whether or not the defendant served by publication. In Section D, that's going to be with personal service. With personal service, this is going to someone's home, their primary place of residence. And in this situation, when they're served personally, they're going to have a much shorter time, right? They're going to have 14 days from the time of service in order to answer. The thinking is that you've already received the documents. You should be able to get something going insofar as your response in a timely manner. In Section E, this kind of addresses the situation where if there's service by publication. Service by publication's really broad. For example, putting service into an actual newspaper. In this situation, the defendant's going to have 42 days to respond. Thinking is that it's just widely disseminated. It's not as personal, so they're allowed a little bit more leeway in order to see the actual service and have notice satisfied. Are you tracking that so far? Excellent. Moving along. Now we see how it all comes together. We already understand now at this point the general 5 parts of the 503.1, the default judgment rule, and now we know how the answer works. So we have to see how it all comes together. Left to right, up to down, if you guys want to read along. So first, what's going to happen, defendant fails to answer in a timely manner as described by Rule 502.5, which is the answer rule. At this point, they have to ensure that service was proper. That's notice, right? We have to ensure they were properly noticed. Well, they received proper notice as a result of proper service. And then, if it's determined that service was proper, they have to render a default judgment in the proper manner. Important to note, though, as far as the notice goes, while they do have to ensure that it was proper, they may or may not be able to hold a hearing for this purpose. So that's up to the judge's discretion. So now, in that middle section, that's really referring to those like subsections 1 and 2 of A of 503.1. And this is going to dictate the manner in which the default judgment is rendered. Like I said earlier, the main distinction is whether or not the claim is based on a written document. If it's based on a written document, which is entirely possible to happen and would really kind of be an ideal outcome for a plaintiff. If the document actually has all the relevant information and it's signed by the defendant and there's an affidavit from the plaintiff assuring that it's a true and accurate copy, and everything in the document will be able to correspond to all the claims against the defendant. In this situation, they won't have to request a separate hearing for damages, right? This is a rather high burden to meet. There's a lot of things that have to happen. If you'll look, there's 2 highlighted red ands, which means it's going to have to be, all these things are going to have to be met in order for the claim based on the written document to go forward without. But in other cases, what's going to happen is a separate hearing is going to have to be established for evidence of the damages, right? And that's if the claim is not based on a written document. Maybe if it's, for example, maybe a car accident comes to mind. There's no written documents there. Well, there are, but anyways, I digress. But if the plaintiff proves its damages in the situation where it's not based on a written document, judgment for the plaintiff in the amount proven is given. But if at this point the plaintiff is unable to prove its damages, judgment is rendered in favor of the defendant. And then at the end, we see 505, the rule that we talked about the least, and that just enumerates the information that's going to have to be in the judgment, the rights and parties, state the rights of the parties involved, be signed by the judge, and state who must pay. That wraps up my presentation on default judgments. Do we have any questions? Yes.
I understand the judgment now.
Yes.
What's the real advantage?
Well, I mean, the advantage for the person, like the plaintiff, well, they wouldn't have to go through, if they were going to trial, they wouldn't have to show up. There's going to be less fees, I imagine, associated with that as well. And they damages that they prove they may have a easier time proving the damages.
Or that the interpreter is on Zoom, we're going to start file, but
What does that mean?
Thank you.
Oh, thank you. Thank you for your time, everyone.